In recent weeks in Victoria, police have been seen detaining people and demanding they show ID to prove they're within 5 kilometres of home, provide proof of an exemption from wearing a mask, or otherwise harassing them over the current lockdown. This is often done in a highly intimidating manner with as many as 10 to 12 police officers surrounding the person. In this video, we'll have a look at the relevant section of the Crimes Act, as well as a case from the Victorian Supreme Court that relates to this. Note that I'm not a lawyer. Don't believe anything that someone on the interwebs tells you, including me. Research it for yourself. I'll give you the information to confirm what I say. Because I'm not a lawyer, I don't know if there are other laws that might be relevant, so before you take any action, talk to a lawyer. Imagine you're sitting in a public park with your family having a picnic when suddenly a group of police officers approach and demand you produce ID to prove you're within 5 kilometres of home, threatening to arrest you if you fail to prove your innocence. This is not a made-up scenario. It's happening right now in Melbourne. How would you react? Most people don't know the law and they'll just believe what the police tell them and comply. Those who are aware of the law and don't provide ID can expect to be put under high levels of duress, including being threatened with arrest if they don't comply. What is the legality of this police behaviour? The first thing I want to say is that make sure you video record all encounters with the police. Immediately get out your phone or some camera and start video recording. This will be a high-stress situation and you can easily forget exactly what was said, and you also may need it for evidence. Let's look at the Victorian Crimes Act 1958, which allows police to demand your name and address in specific circumstances. I put a link to the legislation in the description below. The circumstances in which police can do this are covered in Section 456AA subsection 1. A police officer or a protective services officer on duty at a designated place may request a person to state his or her name and address if the police officer or the protective services officer believes on reasonable grounds that the person A. has committed or is about to commit an offence, whether indictable or summary. Take note of the specific circumstances in which this can be done. First, there must be an offence, and secondly, they must have a belief on reasonable grounds that you have committed or are about to commit the offence. Subsection 2 of the Act continues. A police officer or a protective services officer who makes a request under subsection 1 must inform the person of the grounds for his or her belief in sufficient detail to allow the person to understand the nature of the offence or suspected offence. This gives us a third point. They must explain the grounds for their belief, and it must be in sufficient detail for you to understand it. It's not good enough for them to just claim you've committed an offence. The law requires them to explain it to you in detail so that you can understand it. What sort of detail would this be? Here's a few things that I would want to know so that I could understand it. What is the law that I've supposedly broken, in particular the Act and section plus subsection if relevant? This is critical information that you'll need to fight any fines or charges. What is the actual offence? In other words, an explanation of what I've supposedly done wrong. What grounds do they have to believe that I've committed the offence? In particular, what is the evidence that they have that leads to this belief? Depending on the circumstances, other relevant details. Once the police officer or PSO has met these requirements, subsection 3 says you must provide your correct name and address, or else you will have committed an offence. At this point, you don't have to provide anything else. In many of the videos I've seen of recent police encounters, the police claim that the person must prove their identity, and they make threats to arrest for non-compliance. But notice how the Act does not say that you must prove the details you stated are correct. It doesn't say that you have to provide your driver's licence or state your date of birth. All it says is you must state your name and address. I don't know of any law that requires you to prove your identity outside of some specific situations such as when you're driving a motor vehicle or purchasing alcohol. If you do know of any, please let me know in the comments. Make sure you state the Act and the section that allows police to do this. If the police want to verify your identity, they can do it, but verifying it is their problem, not your responsibility. In other words, they have to prove your guilt. You don't have to prove your innocence. By stating your name and address, you've completed your obligation under this Act, and the police have enough information to take action regarding the original offence, such as issuing you a fine. Police officers want to verify your identity so they can determine whether or not you've committed the offence under B or C, giving a false name or address. By verifying the details that you stated, they are actually investigating a potential offence. But the Supreme Court of Victoria has ruled that the police have no power to detain or arrest you specifically for any questioning or investigation, and it is unlawful for them to do so. Let's go and look at a case that dates back over 50 years. This is the case referred to as Regina versus Banner, and it involved a man suspected in the disappearance of a woman. The police didn't have any evidence and arrested and held him for the purposes of questioning him. Here's what the Supreme Court said about that. Police officers have no power whatever to arrest or detain a citizen for the purpose of questioning him or of facilitating their investigations. It matters not at all whether the questioning or the investigation is for the purpose of enabling them to ascertain whether he is the person guilty of a crime known to have been committed, or is for the purpose of enabling them to discover whether a crime has or has not been committed. If the police do so act in purported exercise of such a power, their conduct is not only destructive of civil liberties, but it is unlawful. For to imprison any person without lawful justification is a civil wrong for which damages are recoverable and may also constitute a common law misdemeanour punishable by fine and imprisonment. This is the most widely cited case I've found, and later in the decision it states that the power of detention is merely for the purpose of taking them before a magistrate to be dealt with according to law. If the demand is made that you do anything apart from supply your name and address, and police use your detention to try and force you to help them in any investigation, they are acting unlawfully. Those are not my words, that is what the Victorian Supreme Court said. Up to now, we've looked quite closely at the powers the police have to demand your name and address, and what you must do when they exercise those powers. The rest of Section 456AA also gives you powers that you need to exercise. Let's go back and continue reading the Act at subsection 4. A person who is requested by a police officer or a PSO under subsection 1 to state his or her name and address may request the officer to state orally or in writing his or her name, rank and place of duty. Subsection 5 is almost identical to subsection 3, making it an offence for the police officer or PSO to refuse to comply with your request or give false information, and it carries the same penalty as subsection 3 does. When you invoke the powers in subsection 4, what I strongly recommend you do is request their details in writing. If you only request them orally, you might forget them. If you're relying on a video recording, it might get lost or not record properly. Demand they provide their details in writing. Many police officers will have a business card. If they don't have a business card, it's their responsibility to supply their details in writing. Don't let them off the hook if they claim they haven't got anything to write on or with. If they don't comply with your requests, they have committed an offence. In your encounters with police, you'll probably get a lot further if you can quote laws at them. I urge you to memorise the section number of this law we've been talking about. It's actually pretty easy. Crimes Act, section 456AA. 456 is simple to remember as you're just counting in order. 4, 5, 6. The simple act of quoting this to the police officer combined with an understanding of what the law says will put them on notice that they can't bluff you with unlawful claims. If they're insisting you give them your date of birth or ID, you can say something like, Section 456AA subsection 1 of the Crimes Act only requires me to state my name and address and I've complied. Can you show me any other law that requires me to provide that information? I'm happy to comply with any lawful order, but I know that this law only requires my name and address. Up to now, what we've been saying has been theoretical. Let's consider an actual example where a police officer has approached you and demanded that you provide your ID to prove that you're not more than 5 kilometres from home. What I want to do is show you how to ensure that this proceeds lawfully. The first thing to do, of course, is pull out your phone and start recording. Next, ask them if they're detaining you or if you're free to leave. If they're not detaining you, consider immediately leaving. Ask them if they're requesting your details under Section 456AA of the Crimes Act. Ask them what law they suspect you of breaking. They should say something related to the state of emergency under the Public Health and Wellbeing Act. To understand these powers and how they're exercised, I recommend that you watch my video that goes into this in detail. Ask them to explain their reasonable belief that you've committed the offence in enough detail for you to understand it. There needs to be something that has given them cause to come to this conclusion. For example, if you're in a public location and there are homes less than 5 kilometres from that location, they have no reason to suspect you of not living in one of them unless they have some other information or evidence. I would never claim to live in one of them, but I'd specifically ask them what is their reason to suspect that I specifically don't live in one of those homes. Try to get into the habit of asking them questions, never stating anything. As we've seen, the only thing this Act requires you to state is your name and address, and that is only after they've complied with subsections 1 and 2. So ask them what it is that makes them suspect you of not living in one of those homes compared to every other person who's in the area. They must be able to explain this to you for them to have reasonable grounds. If they can explain reasonable grounds for their belief that you're more than 5 kilometres from home, then you need to state your name and address. But as soon as they demand anything more, remind them that Section 456AA only requires you to state your name and address. Don't let them bully you into anything else. Remember that any investigation is their problem, not yours. And as the Supreme Court ruled, they cannot use detention or arrest for the purpose of carrying out an investigation or questioning you. Once this has been done, remember to request their name, rank and place of duty in writing. If you can find someone to role-play some scenarios with, it will really help you if you do encounter police. Practice makes perfect, so get a friend to play the part of a police officer and practice it with them. You can find videos of actual encounters on social media, so watch a few of them to see the sort of things that the police like to say. This will give you the opportunity to come up with a response to their claims. As I said at the beginning, don't believe anything that some random person on the internet says, including me. I'll always include links to the information I've used so that you can verify it, and I strongly urge you to look this up for yourself.